All right, joining me once again here on the Matthew Filipowicz Show is my good friend Amanda Marcotte. Amanda is an author, a writer, a blogger. Her work has been seen in Slate, Salon, and Alternate. She is the writer of the Pandagon column at Raw Story, which you can find at rawstory.com. You can also follow her on Twitter at Amanda Marcotte. Amanda, thank you so much for being on the show again.
Thanks for having me.
All right, so Amanda, you recently wrote about the Hobby Lobby Obamacare case that's heading before the Supreme Court. If people aren't familiar, describe what exactly is the case about.
So Hobby Lobby is arguing against the contraception mandate in the Affordable Care Act. Basically, the Affordable Care Act requires that if you offer an insurance plan, period, but as an employer, if you offer an insurance plan, it has to cover a series of preventive services, including contraception with no copay. But that's just one of literally like dozens of preventive services that have to be offered without copay. It's a cost-saving measure. Contraception, unplanned pregnancy costs insurance companies a lot of money, so it's basically an attempt to like lower prices by encouraging people to use more preventive care. Hobby Lobby, however, is arguing that because they disagree with, I guess, contraception, which again, 99% of women have used contraception. This is like not a particularly controversial subject in the real world, but
or
they
is
seem to
it?
think it is. Yeah, they seem to think it is, and they're suing, saying that they shouldn't be required to cover it under the Religious Freedom Restoration Act and the First Amendment. So there's two kind of separate arguments going on, and the argument, and this is incredibly important to understand going forward, there were 90 cases brought to the Supreme Court from different employers who don't want to cover contraception. But interestingly, the ones that the court has decided to take on were levied by Protestant employers, not Catholic employers. And this is interesting because the Catholic employers and we're not talking about like Catholic hospitals or anything like that. We're talking about like private businesses. But the Catholics were arguing just against contraception generally. The Protestant lawsuits are basically making this argument that they don't want to cover certain kinds of contraception, such as the birth control pill, the morning after pill, and the IUD, because they believe those are the equivalent of abortion. So
Wow.
This is going to swing in no small part, and that's a distinction that apparently the court seems to think is interesting. It kind of implies that you can't just sort of generally be against contraception, and that you have to somehow believe that it's taking of a life of some sort. So I think that'll be interesting going forward, because it suggests that the court might be trying to find a way to allow companies to deny contraception benefits without creating a general ruling that would say that your boss can just remove any like healthcare benefit just on a whim and say Jesus told them to, you know?
Well, no, and like let's get to that part again about the difference between like taking a Catholic lawsuit or a Protestant lawsuit, but let's get to that in a minute and go in a little deeper into that. But you actually compiled a bunch of possible arguments about different types of if this case were to be upheld by the Supreme Court as a moral objection, and that's strictly a moral objection of birth control, the amount of things that could ultimately be denied by an employer is pretty vast, and it really would set a really ridiculous precedent.
Yeah, so this is the concern. Okay, it doesn't seem to me that there's a way for the Supreme Court to, in good faith, argue that an employer can make a religious objection to providing a health benefit without expanding that to any religious objection that anyone might make, right?
Right, yeah.
So that's why the Catholic Protestant thing is interesting, because, you know, it just seems it would be unfair to say, okay, we're going to let you deny contraception benefits, but, you know, if you're a Christian Scientist, you still have to cover people's health care, even though you object to doctors. Or maybe
if you're a Scientologist who doesn't believe in psychiatry, you can't cover that at all. You can't cover mental health care. stuff like that.
Exactly. A Jehovah's Witness might deny you blood transfusion. I mean, there's all sorts of medical care that there are legitimate theologically argued. So, like, part of the case when you go before the court is you have to basically say you have to prove your religion actually believes this. So, there's anti-vaccination arguments. There's all sorts of arguments floating out there. So why it's interesting, after I wrote that piece, it became clear that they were only picking up the Protestants because they realized that, I think that my speculation is they realize that that's a problem. That they don't want to just grant this wide right to just let your boss dictate your medical care.
Yeah, and that's so weird, and it's also really, really, honestly, it's, one, that precedent would be dangerous, but also you would think hopefully the court's not ridiculous enough to make it, but they might. They made a lot of ridiculous things so far. They made a lot of horrible rulings, especially this court. But so the fact that they'd even try to tie birth control to abortion, I don't even, so it's just that, not even that life begins at conception, it begins at ejaculation or something like that? Is that what they'd essentially try to say?
Well, no. So what the lawyers what the court is going to probably consider is like whether or not abortion is a serious enough objection that it's more important than like the blood it ends up being more of a burden to the employer than they say, like the blood transfusions and other arguments that could come up, right? Uh-huh. So, like, already abortion, you don't have to cover abortion. So that precedent's been set. So basically, they're trying to expand the definition of abortion to include what I like to term female-controlled contraception. I like to use that term because it really gets to the heart of what's going on here, because none of these contraceptions that Hobby Lobby is claiming are abortion are actually abortion.
Or maybe they are, though. Let's look at their side of it. Maybe they are.
They're not. That's an unscientific argument. They argue that the birth control pill and the IUD work by preventing fertilized eggs from implanting, which isn't abortion by any medical definition, even if that's how they work.
Yeah.
Because abortion is terminating a pregnancy, and preventing a fertilized egg from implanting would be still preventing the pregnancy, which doesn't begin until implantation.
Yeah.
But beyond that, that's not how they work. The birth control pill and emergency contraception, and this has been scientifically demonstrated, work by preventing ovulation. The IUD works, they're pretty sure it works by causing sperm to lose its mind and not know where to go. I'm serious.
Yeah.
And, like, literally, like, so a lot of anti-choicers will fall back, well, it could work that way. It could prevent fertilization. Well, so could jumping up and down really hard, so could aspirin, so could sneezing, so could sleeping on. Like, we don't know what causes fertilization or fertilized eggs not to implant.
Right.
We don't know. Like,
having a spicy dinner, maybe? Yeah.
Yeah, spicy food. Like, I mean, what, are you just going to put women's bodies in a bubble? Like,
yeah.
even that probably wouldn't work.